Assalamualaikum and a very good afternoon. We are from Group 14. We'll be presenting about hire purchase. Our group member is me, Ade binti Azli, Nur Fatina Bila binti Zarawi, Laylatul Qadrina binti Hairul, Nur Izzati binti Jailani, and Nurul Afifah binti Muhammad Noor. For introduction, hire purchase is an action of buying that included in the first schedule as stated in the Act. Hire purchase is an action to legalize the practice and methods of hire purchase agreement, the factual and obligation of parties to practice the agreement. In Section 2, Subsection 1 of Hire Purchase Act 1967, hire is a person who takes or has taken goods from an owner under a hire purchase agreement and includes a person to whom the hire right and liabilities under the agreement have passed by assignment or by operation of law. Under Section 2, Subsection 1 of Hire Purchase Act 1967, owner is a person who let goods to a hire under a hire purchase agreement and includes a person to whom the owner rights or liabilities under the agreement have passed by assignment or by operation of law. The first schedule, the list of goods in the first schedules are all consumer goods, motor vehicle, namely invalid carriage, motorcycles, motor cars, including taxi cabs and hire cars, good vehicles, where the maximum permissible laden weight does not exceed 2,540 kg, and buses, including stage buses. Formation and nature of hire purchase agreement. A hire purchase agreement includes a letting of goods with an opinion to purchase an agreement for the purchased goods by installment. Such an agreement differs from a contract of sale. In a hire purchase agreement, property in the goods does not pass at the time of the agreement while in a contract of sale. Property in the goods passes at the time of the agreement or at any time before the goods. Contents of hire purchase agreement. Every hire purchase agreement shall have first, specify dates on which the hiring shall be deemed to have commenced. Second, specify the number of installments to be paid under the agreement by the hirer. Third, specify the amount of each of these installments and the person to whom and the place at which the payment of their installment are to be made. And the last one is specify the time for the payment of each of those installments. Minion Corporation City Number versus Haji Nordin. The court gave a decision that the enforceability of a hire purchase agreement was not affected if the hirer signed an agreement with blank spaces, which were later filled in by the owner provided that the hirer was aware of the term and knew that he was signing. The defendant in this case has signed an agreement with a certain portion of it were blank. The particulars were filled in after the agreement was signed. Warranties and conditions. Many contracts include either warranties or conditions, sometimes both. They are not required parts of a contract. However, parties often include them to clarify what they expect of one another. There are major differences between the two, but each has important implications for the parties' duties and rights. Difference include the following. The first one is conditions are considered more important stipulations in the development of the contract. Warranties are of lesser importance. Second, a condition must be performed prior to the completion of another action. A warranty, as contract, is essentially a promise that the fact a buyer gives a seller a genuine. The last one is the objective of the agreement is directly associated with the condition. Warranties are simply subsidiary provisions that are related to the contract objective. There are three implied conditions applicable to all hire purchase agreement. The first one is the right to sell. Section 7, subsection 1b of Hire Purchase Act. The owner shall have the right to sell the goods at the same time when the property is surpassed. Second, merchantable quality. Section 7, subsection 2 of Hire Purchase Act. The goods shall be merchantable quality. Grant versus Australian Knitting Mills Ltd. The court held that merchantable quality does not mean that the thing is sellable in the market simply because it's alright. It's not merchantable if it has defects unfitting it for if only proper uses but not apparent on ordinary examination. The third one is fitness. Section 7, subsection 3 of Hire Purchase Act. The goods must be reasonably fit for purpose except in following circumstances. First, if the following are second-hand, and the last one is all conditions and warranties of the fitness are expressly negative, and the owner proves the hirer with acknowledges in writing the statement was brought to his shoes.
Liability of owner and dealer for misrepresentation. The hire has the right to rescind or repudiate the agreement, to terminate the agreement, and sue for damage if the person who makes the misrepresentation is the owner, dealer, or her agent. However, the scenario would be different if a financial institution took the place as the credit provider and enter into an agreement with the hire. The dealer would merely act as third party in this case. If the dealer makes a misrepresentation, the hire can only sue for damage but has no right to rescind or repudiate the agreement. Section 8, subsection 1A of Hire Purchases Act. If the owner made misrepresentation in the course of negotiation leading to the hire purchase agreement and sue for damage. Section 8, subsection 1B of Hire Purchases Act. The dealer sells the goods to the finance company, which will in turn enter into hire purchase agreement with the hire. The dealer would then only be a third party to the hire purchase agreement. Therefore, in the event that the dealer has made a misrepresentation, the hire cannot repudiate the agreement. He can only sue for damage.
So next, I will elaborate about reposition by owner. The owner is entitled to recover possessions of the goods when the hirer has committed a breach of his contractual obligation relating to the payment of installment under the hire purchase agreement. The Hire Purchase Act 1967 lays down various restrictions on the power of the owner when recovering possession. Firstly, notices must be given to the hirer when goods are to be repossessed in Section 16. After the repossession, the owner must not sell or dispose of the goods for 21 days in Section 17. Hirer right and immunities when goods are repossessed also in Section 17. Hirer can regain possessions of the good in certain circumstances in Section 19. Okay, first of all, we're gonna look into procedure for reposition. Firstly, default in payment. Secondly, service of 4th schedule notice. Thirdly, reposition. Fourthly, service of 5th schedule notice and procedure of the reposition. And lastly, selling on reposition by the owner. Next, notice must be given to the hirer when goods are to be repossessed in Section 16. If the hirer defaults in 2 successive payments, or if he defaults in the final payment, the owner can only repossess the goods after certain procedure. Firstly, he must serve on the hirer a notice in writing of his intention to retake possession. Secondly, the period fixed by the notice must have expired and not be less than 21 days. Thirdly, the owner must personally deliver to the hirer a document acknowledgement receipt of the goods. Fourthly, the owner must serve on the hirer and grantor, if any, a notice in writing in the form set out in the 5th schedule of the said Act within 21 days. If the hirer is deceased, an owner shall not exercise any power of taking possession in Section 19(1)(a). If the hirer returns goods in 21 days after the service on him of the notice in the form set out in the 4th schedule, shall not be liable to pay the cost of repossession, the cost of incidental to taking possession, and lastly the cost of storage. Where the goods are returned to the hirer pursuant to subsection 1 and any breach of the hire purchase agreement has not been remedied, the owner has no right arising out of the breach to take possession of the goods Section 19(2) unless, first, by notice in writing given to the hirer at that time of the returns of the goods, he specified the breach and required it to remedy. Secondly, the hirer failed within 21 days or within the time specified in the notice. After the repossession, the owner must not sell or dispose of the goods for 21 days in Section 17. Hirer right and immunities when goods are to be repossessed in Section 18. Upon receipt of the 5th schedule notice under Section 16(3), the hirer may within 21 days give notice to the owner, requiring owner to redeliver to him goods that have been repossessed in Section 19 or sell the goods to any person introduced by the hirer section in Section 18(1)(a). Hire can regain possession of the goods in certain circumstances in Section 19. The hirer can regain possession of the goods in 21 days after giving notice to the owner pursuant to Section 18(1)(a) to pay to the owner any amount due to the hire purchase agreement, remedy any breach of the agreement, or pay to the owner where he is unable to remedy the breach by reason of the fact that the owner has taken possession of the goods, or pay to the owner the cost and expenses reasonably and actually incurred by the owner in doing act, matter, or thing necessary to remedy the breach. Lastly, to pay to the owner the reasonable cost and expenses of the owner of the incidental to his taking possession of goods and his returning them to the higher section.
Okay, this is a case law for repossession by owner. Wang Brothers Motors in Berhad vs. Lee Aiseng 1978. Fact: a car was taken by the respondent on hire purchase with appellant. The respondent failed to pay the installment due and the appellant issued a notice under Section 16. Section 16 clearly specifies that the period before which the seizure can take place shall be not less than 21 days. After the service, the notice was therefore bad in law, even if served, and its effect was therefore null and void. Okay, this is a procedure for the repossession that can apply in the case. The owner can only repossession the goods after following certain procedure, which are as follows. A. He must serve on the hire a notice in writing of his intention to retake possession. B. The period fixed by the notice must have expired, and this must not be less than 31 days. C. The owner must personally deliver to the hire a document acknowledge receipt of the goods. If the hire was not present at the time, the owner must send to him immediately after taking possession of the goods a document acknowledge receipt of the goods. The document must contain a description of the good and date, time, and a place at which the owner took possession of it. D. The owner must serve on the hire and guarantor, if any, a notice in writing in the form set out in 5th schedule of the said act within 21 days after he has taken possession of the goods. The owner cannot sell or dispose of the goods without the written consent of the hire until expiration of 21 days after the date of service of the said notice in Section 16, Hire Purchase Act 1967. Okay, this is an insurance. An owner shall cause to be insured in the name of the hire. First, motor vehicle comprised in a hire purchase agreement for the first year only. All other goods comprised in hire purchase agreement for the duration of time that the good remain under hire purchase. Again, any risk that hitting fit Section 26, where the good comprised in a hire purchase agreement is a motor vehicle. It shall be the duty of the hire to cause the said vehicle to be insured in respect of the second and all subsequent years that the motor vehicle remains under hire purchase. Okay, this is the case law for insurance. Malaysian National Insurance in Berhad vs. Abdul Aziz bin Mohammed Daud, 1979. The policy of insurance covering the car states that the company shall not be liable with whilst any person other than authorized driving was driving the motor car. In this case, the defendant was driving his father's car when it was involved in an accident. The defendant and his father were named as authorized drivers subject to the following provisions. Provide that the person driving is permitted in accordance with the licensing or other law and regulation to drive the motor vehicle or has been so permitted, and is not disqualified by order of a court of law or by any reason of any enactment of regulation in their behalf from driving the motor vehicle. At the scene of the accident, by the respondent had an expired driver license, but no court has disqualified him from holding or obtaining a driving license. Help. The second limb previously envisaged the respondent's situation where there was a technical lapse to renew his driving license. Thus, the respondent was insured under the policy. Decision was upheld by the federal court. Okay, the last is fraudulent sale of goods by hire. Every person who, by the disposal or sale of any good comprised in hire purchase agreement, or by the removal of the goods, or by any other means, defraud or attempt to defraud the owner shall be guilty of an offence under this act and shall, not conviction, be liable to a fine not exceeding 10,000 ringgit or to imprisonment for a term not exceeding 3 years or to both. Section 38. Okay, this is the case law for the fraud. Kaim Credit and the Leasing Sdn Bhd B.S. Pang Kim Cha, 1988. A hire purchase agreement is signed between the tenant and the buyer. The tenant is required to pay a rental of the item, even if he does not benefit from the rental item. The plaintiff has sued the defendant for failing to make his rental payment when the machinery was rent through the hire purchase contract has been damaged by the fire. Defendant did not make the rent payment because awaiting a claim from the insurance company. Yet the court has ruled that defendant who rent a machinery from the plaintiff through a hire purchase contract must proceed with the payment rental of the machinery even if the machinery is damaged and unusable. For conclusion, a hire purchase agreement is an agreement that is precipitated on the general rule of the contract of law of over acceptance on the part of the hire and that of the owner, sometimes with the dealer acting as the agent of the owner. It pertinent to note that obligation of the buyer and that of the owner of a concurrent obligation and that must be done in line with each other obligations. Thank you. That's all from my group. Assalamualaikum.